side. There were kind of cost one yes, cost of more private restaurant then application of treatment. But if I was not including their application, it's solvable. And second one, if you treatment partner is supposed to request you have to better distribution because entire appointments are taken to subject to the outcome of case circuit pending in the Supreme Court. The we are the diploma holders first. We output from the selection list to part of the vacancies with these BA degree holders when we eligible by the
What was the interim relief?
in this case, Manav, was that the entire appointments can take place subject to the outcome of the assessment pending. That was an order. Against this, they also this order was also taken before the Honorable Supreme Court. It is of 2nd July.
So the interveners in IA 778 and 3343 has to have to argue. Okay.
Yes.
So you-
Candidates, number of employees of the respondent who are not BA and who are not having the requisite training. So there are orders not that they are being sent for training. They are not having any BEd or DLEd, anything. So they are being sent for training. And here we are, we have responded in accordance with one to which we are satisfied. I'm not even definitely undergo that training course. I'm not saying away. But I just want to point out that you can't have double standard when the totally untrained candidates are there. But it's real.
So we hear on this IA first. Why should we entertain the IA?
Well, I have tried the nation.
Okay.
As per the directions passed by this court, the last bit, tried the explanation. And
As an IA,
My clients are not at fault, not at
so it will not ever adversely affect me also.
who is representing the IA?
I'm representing on both these guys.
Both.
Yes. So Maharashtra, please have a
And Mr. Rupra, you are for?
I'm also for similarly placed. They have been appointed on the basis of BA, just like the clients of my level, and we are in fact saying the same role.
You are also interveners.
So, intervene, my lord, if
You
you
have
would
a-
allow that.
even my application.
You were also a party there in the Supreme Court.
No.
None of
That
the
is not a limitation against me.
none of
But my learned friend will give explanation for his clients, and his clients are hundreds in number. One or two or three may have been.
All.
deserves consideration. or-
Yes, Mr. Zillia.
Before I proceed further, as per my information, both these petitions have been rendered infructuous because these petitioners have already been appointed. It's an academic question as far as these petitioners are concerned. They have already been appointed or as per their qualification of DLA. Therefore, whether one of these petitions are to be heard, because they are already and they have not disclosed this fact. They are blaming us. They have not disclosed this fact that they are already appointed. They should have first come and inform the court that these petitioners have already been appointed. As far as my applications are concerned, Parosh may kindly see. Just place one of the brief sequence of the events and then I will show the law. ये इशू को सेंसिलाइजेशन करने से इनका काम नहीं बनेगा। Parosh में 10 कह दिया करो। ये कंफर्म कर दें सर इस बात को कि इनका अपॉइंटमेंट हो गया कि नहीं। They are blaming us for not disclosing. Have they disclosed this fact before requesting the court to argue these matters? Have they brought their appointment letters on record to show that they have already been appointed? Yeah, that is the situation here. The first thing they ought to have disclosed that they have been appointed.
So what did the Supreme Court say after that judgment of?
Now the Supreme Court says, Supreme Court has not said anything about our appointment. Supreme Court has merely declared the law. Supreme Court said that in view of the provisions of the RT Act, the notification issued by the NCT whereby the persons having B.Ed degree were declared eligible for appointment on the post of primary teacher, that notification is bad. And therefore, not the as on today Supreme Court said that the persons who were having DLED degree, they were eligible for appointment. But Supreme Court has simultaneously said that now it is to be decided by the respective.
No, but I think Supreme Court was again approached.
Yes.
What happened in that?
Supreme Court, my lord, what has happened? My lord, they are relying on a behalf of their three judges bench they have placed them. Before that, my lord, Chhattisgarh High Court. In the Chhattisgarh, the process of recruitment was stayed by the Chhattisgarh High Court in view of the decision of the Supreme Court. That Supreme Court has declared it ultra virus, and therefore they said that recruitment cannot go. The matter was travelled before the Supreme Court against the order passed by the Chhattisgarh High Court. Supreme Court said that the process of recruitment cannot be stopped. Let the process of appointment go in the Chhattisgarh. This is after the order passed by the Supreme Court in this Devesh Kumar. Now they have pointed out one of these three judges bench. Now, please see, there the Supreme Court has said again. Supreme Court has left the matter to the Bihar government. Though they have said they have only said that what recruitment process is illegal pursuant subsequent to holding of this law as bad. They have said, but they have not declared that process of recruitment in Bihar as void, or they have not quashed that process.
Where are those two orders?
On violation, serial number 4.
और इसके बाद सर मैं अपनी आईए पर बहस कर देता हूँ। जो मैंने उसका क्या इफेक्ट होगा वो मैं बता देता हूँ। What is the law on that?
123 is some Bhagwan Krishna.
Yes, that is the Bihar judgment. It's a three-judges bench judgment. And operative country that they court. Yeah, you did first. pages Manav summarize the entire fact of the judgment.
Which page?
Page 123. I can read Manav from page
23. Yes.
The present petition has been instituted by the petition seeking invalidation of a notification dated 28/2018 issued by the National Council for Teacher Education in terms of direction of the central government given under section 1 of right of children to pay in compulsory education act 2009. This notification introduced certain amendments to an earlier notification dated 23rd August 2010, laid down necessary qualifications for teachers who will be primary as also upper primary level. Substance of the amendment notification was that the candidates holding B.Ed degree would be entitled to be appointed primary school teachers subject to fulfilling certain other requirements. In the judgment of this court delivered in civil up 5068 of 2023, arising from SLP civil titled as Devesh Sharma versus Union of India of 2023, the said notification has been directed to the required. This judgment, this court upheld the decision of the Rajasthan High Court quashing this said notification. He applied the ratio of the said judgment in this petition. The present petition stands allowed in terms of layer A to the extent the same relates to the notification issued by the NCT on 28 June 2018. Consequential advertisements and other subsequent steps taken in consequence thereof shall also stand invalidated. The state of Bihar is not a party for this court in this petition. As such, we make no comment as regards the notification issued by the state of Bihar, the legality of which have been challenged in this petition. But this court expects that the state of Bihar shall take into account the judgment of this court delivered on 11th August 2023. So, my lords, the consequent advertisement and all other steps taken therewith in pursuance to the notification of 28/2018 was declared invalidated. So, my lords, in very clear terms, all such appointments of the B.Ed degree holders, they were stands quashed. The consequential steps had to be taken by the concerned states. The same thing, my lords, here in this before this honorable court, my lords, the writ petition was filed. As soon as the advertisement took place, this honorable court made all appointments subject to the outcome of the SLP, which was decided by the order of 11th August 2023. Now, as when the notification of the NCT goes, the consequential rules under challenge made by state of Madhya Pradesh, they also, my lords, are consequentially invalid and illegal. And in view thereof, all appointments of the B.Ed degree holders as primary teachers, they also, my lords, become illegal and are required to be questioned.
But my kindly see one of the order. I'll just read one paragraph. Page 124 as the last paragraph can be read. What the Supreme Court has said. My friend is adding words to the judgment passed by the Supreme Court that all appointments are request. Let's see that as the Supreme Court says that. Supreme Court says the present petition stands allowed in terms of prayer A. Very specifically, prayer A to the extent that same relates to the notification of the NCT on 28/6/2018. ये तो पहले डिक्लेयर हो गया देवेश शर्मा में, इसमें कौन सी नई बात कही सुप्रीम कोर्ट. इसके बाद सर आगे देखें, consequential advertisement, other subsequent steps taken in pursuance thereof shall stand invalidated. The state of Bihar, one of the Supreme Court said the state of Bihar is not a party before this court in this petition, as we make no comments as regard to the notifications issued by the state of Bihar, the legality of which have been challenged in this petition. But the court expects that the state of Bihar shall take into account the judgment of this court delivered on science. So the Supreme Court has not invalidated that. Supreme Court said that let it examine and let the decision be taken by the state of Bihar. Now my friend is reading this that all subsequent appointments and everything has been passed. My lord is adding words to the order passed by the Supreme Court. And that is what we are saying. That in view of the invalidation of the notification dated 28/6/2018, the matter has to be examined by your lordship here. And that is what the Supreme Court in the main judgment of Devesh Sharma has also been said. Supreme Court has said in so many words that once there was a notification dated 28/6/2018, the state was bound to follow that notification. And Supreme Court said that the state did not have that liberty to ignore the notification dated 28/6/2018. So everything has to be examined in the light of both observations. Merely by saying that Supreme Court has said in Devesh Sharma that the notification is bad, my lord, everything does not get invalidated on its own.
Yes, now let us go to the IAS.
Now, Manoj, may please see the IM.
IAS.
Write the explanation, and my explanation may kindly see, because I have given a sequence of events. Manoj, I'm referring to this now, this WP 13768. History number.
Yes.
In this number, I have filed this explanation.
Which para?
Or my paragraph 3 onwards, Malord, may kindly. I just then Malord, I what has happened, Malord? Just paragraph 3 may kindly. The matter in issue in the present petition is primarily the validity of the notification dated 28/6/2018 received by the NCT, by which the candidates having their qualifications were made eligible for being appointed as teacher in primary school, as has already been brought on record before the court. The aforesaid notification was struck down by the Honorable Rajasthan High Court by a judgment dated 25/11/21. The aforesaid judgment was challenged before the Honorable by the candidates on the state of Rajasthan who were applicants in the selection process for appointment of teachers to primary schools in the state of Rajasthan. That by an order dated 4/22, the Honorable Supreme Court was pleased to issue notices in the special leave petition, which was the leave matter filed by Devesh Sharma, who was an applicant in the selection process in the state of Rajasthan, and by virtue of that had filed a special leave petition. Subsequently, several other applicants in the process in the state of Rajasthan filed a special leave petition before the Honorable Supreme Court. Notices were issued in all such special leave petition, and they were tagged with the leave matter. New copy of the entire order sheet, starting from the order dated 4/2/2022, SLP number so and so, before the Honorable Supreme Court. Now, I have placed all the order sheets from the first day onward itself on record. That thereafter various orders were filed by the Honorable Supreme Court from time to time, and it is pertinent to refer to the order dated 24/8/2022. By this date, several applications seeking intervention in the special leave petitions had been filed, and by this order, the Honorable Supreme Court was pleased to allow all such applications seeking implement of intervention. In Malord, may kindly see, the order by the Supreme Court was passed, Malord, on 24/8. Now that 24/8 order may kindly be seen, Malord, that order is placed on record, and that is on page 24/8, Malord. This order is Malord, may kindly refer to page 20. Malord, may kindly see page 20.
Yes.
Before that, just page 18, Malord, for the reference of the date, page 18. Page 18, now this on page 18, Malord, to find this is the order dated 24/8/2020.
Yes.
Now, Malord, may have a look on the order. Order is on page 20.
Yes.
Page 20, Supreme Court said permission to file a special leave petition in diary number so and so is granted. Issue notice in diary number so and so, returnable on 12/10/22. Issue notice in SLP number so and so, returnable on 12/10/2020. Then, counsel for the parties had it reviewed that all the matters may be listed for final arguments after 6 weeks. Let list this matter for hearing on 12/10/2022. Meanwhile, Union of India NCTE declared the state's boards of secondary education or other private persons interveners shall be at liberty to file their respective counter affidavit rejoinders to complete the pleadings. All applications seeking intervention impediment are allowed. Interveners are those seeking impediments are allowed to join the proceeding subject to removal, curing of defects. Now, can you see the last paragraph of this order? It is made clear that no further opportunity in this regard shall be done. Now, on that date, all the pending intervention applications, impediment applications were disposed of. They were permitted to intervene in the matter. They were granted time to file their counter affidavit. And after this 24/8/2022, there was no other order by the Supreme Court permitting any of the interveners or making a prayer for impediment was allowed. This was the last order as far as impediment is concerned.
When did you file your application?
Yes, now IAS Malord may kindly come to have filed Supreme Court. I have taken it from Malord website of Supreme Court and lecture A2, page 20. IAS are filed. Malord may kindly see page, it starts from page 22. Malord may refer to page 23. We filed three IAs there.
We means which IAs interveners?
One of this I'm saying. One is Malad the tendency page 23.
Now we are referring to the interveners before this court and which IA?
One that is IA number. Actually, here one.
778 or
One of
334?
this is no, this is. This was IA number 1724.
No, we are only dealing with 778 and 3343.
Well, there are three IAs. Two IAs are filed in 778 and 334. They were filed in this second case, that is between Kumar's case. WP number.
That is IA?
Well, those are the two IAs, not IA number. Well, that is 778.
778 and 3343 is in Kesari number.
That's correct.
And the third, the connected case में कौन सा IA है?
Two है sir 1724.
172. Alright. So now you are referring to interveners in which of these three IAs?
Referring to IA number of this KCB numbers IA case, right in KCB number is one in IA 172.
1724 is in Vipin Kumar.
And just my problem. Vipin Kumar had two IAs. One was 778.
778.
And there was another IA.
That was 3343.
Yes, that was in Vipin.
That is it?
Vipin Kumar. And Kesri Nanda Malad the IA was 172.
17. Kesari Nandan only has one IA.
Only one IA.
Only one is installed here.
Yes.
In your IA, Mr. Rupna?
It is 12981 of 23,
12981
23.
in Kesari. Yes.
2981 23. 10837 of 20.
10
10837.
is no, we are talking about intervener application.
There are two IAs mentioned from Twitter. 12981 of 23.
Yes.
Now Malad the IA which we have.
So when did you? We are talking about IA interveners in which IA right now by referring to Supreme Court intervention.
Here that IA is, here Malad have already given that IA. That is
IA number 1724 of the 2020. These are again 174 of the 2020. On these two IAs, the person will move their application for replacement from other students.
and those IAs were filed.
When were they filed in Supreme Court?
Supreme Court IA was filed, Malad. The first IA was filed on 11/10/2020. That Malad to find on page 23. This is IA number 152181.
And the other?
The other one was filed on 15/11/22. That is IA number 173922. And third IA was filed on 9/1/2023.
And these interveners in these three IAs before Supreme Court were interveners in which IA here?
Here they are in IA number Correct.
Yes. Now you have to satisfy the court. Is it mentioned that they find their?
That's what.
Hmm.
Firstly, Manoj, that we were never allowed to intervene before the Supreme
No, the very fact that he filed it there.
Court. That-
Did you mention it in your present here?
Here we have not mentioned, I've already said, Manoj, there was a mistake. But at the same time, I point out, I'll show the law before your lordship as to whether that matters. The issue is, my lords, we went before the Supreme Court, we filed an application for intervention. Applications for intervention were never allowed. We filed the IA before this court for intervention. Now, my lord, merely by saying that since we did not disclose that fact, it would not amount to suppression of a material. What is material fact? That will have to be seen. What is required to be pleaded, my lord, when it can be objectionable, that will have to be seen. Now, my lords, may please see. Admittedly, my lord, these persons had intervened in the matter before the Supreme had filed application for intervention, and they have filed application for intervention here also. This is also undisputed that this fact that they had filed application for intervention before the Supreme Court, that is not disclosed here, that is also a fact. There is no dispute with regard. The law on the subject, my lord, that I just pointed out before your lordship. The 2006 volume 3, 2003 volume 9 FCC 401. Before that, my lords, may kindly have a look. My lords, may have a look on this.
Which para?
First of all, I'm giving this 2004. Paragraph 13 mechanics.
In which case?
Well, this is 2004 volume 7 SCC 166. Paragraph 13. Whether non-disclosure of admin fact would amount for and make me disentitled to be heard. Paragraph 13. As a general rule, suppression of a material fact by the litigant disqualifies such litigant from obtaining any relief. This rule has been evolved out of the need of the courts to deter the litigant from abusing the process of court by receiving fact. But the supposed fact must be a material one, in the sense that the suppressed fact must be a material one, in the sense that had it not been suppressed, it would have had an effect on the merits of it. It must be a matter which was material for the consideration of the court. Whatever view the court may have taken. Thus, when the liability to Income Tax Act was questioned by an applicant on the ground of her non-resident, the fact that she had purchased and was maintaining a house in the country was held to be a material fact. The suppression of this entitled her to believe it. Now, here I pause for a minute. The Supreme Court says the suppression has to be of a material fact and does not only stop for that, but it must be a matter which was material for the consideration of the court, whatever view the court may have taken. Now, my intervention before Maros, may kindly view it from this angle. I intervened before the Supreme Court. My intervention before the Supreme Court does not affect the outcome of this court's decision or its effect on me. Whether I have intervened or I have not intervened, that judgment pronounced by the Supreme Court is binding on all. So it's not that I was before the Supreme Court and that judgment was binding on me. And by suppressing that fact, I have tried to come out of the binding effect of the order passed by the Supreme Court. The law declared by the Supreme Court is binding on all. And therefore, if I have intervened there, firstly, my lords may have to see that I have not invoked the jurisdiction of the court either before the Supreme Court or before this court. And by compulsion, there's a litigation brought before the Supreme Court. I have not invoked the jurisdiction, I just went there to intervene. Similar is the situation here that there's a litigation brought, wherein I have introduced myself as an intervener. So, my lord, my intervening before the Supreme Court in no manner affects my right to intervene before the High Court. And secondly, one of that fact that whether it is a material fact, that if I do not disclose this fact, my intervention before the Supreme Court would in no manner affect the litigation before this court. So, one of the fact and issue which is to be decided by your lordship, my presence or no presence will not make any difference because I only have to advance my arguments. The result, my lord, whatever the result may be, because the facts which are before the lordship will not be affected. Now, my lords, we kindly see another judgment law that is a recent decision of the Honorable Supreme Court. This is
So in 2003, which is the paragraph you are relying on?
one unjust. इसको देने और अगर तीन फिर मैं then I will come to what is material one. Supreme Court has dealt with that all. इस तरह और this judgment paragraph. This is about 2000. This is on the online.
Yeah.
The SLP number of this 2021,
The citation here.
and this is decided on this.
The citation.
But citation is not. This is.
The 8th December 21 judgment.
Yes.
Shri K. Jairam
Yes.
versus Bangalore Development Authority. Yeah, what is the citation? निकालिए उसको.
मैं दे देता हूँ इसको, ये online दिखा.
Citation तो बताइए इसको.
और इसका मैं online citation दे देता हूँ. This is one of the this civil appeal number 7550 to 920.
Paragraph 12 में क्या है?
और paragraph 12. It is well settled that jurisdiction exercised by the High Court under Article 246 of the Constitution of India is extraordinary, equitable, and discretionary, and it is imperative that the petitioner approaching the court must come with clean hands and put forward all facts before the court without concealing and suppressing anything. Litigant is bound to state all facts which are relevant to the litigation. Now, also please see, a litigant is bound to state all facts which are relevant to the litigation. If he withholds some vital or relevant material in order to gain advantage over the other side, then he would be guilty of playing fraud with the court as well as with the opposite party, which cannot be countenanced. The court, in the case of so has held that a prerogative remedy is not available as a matter of course. In exercising extraordinary power, the court would indeed bear in mind the conduct of the party which is invoking such jurisdiction. If the applicant does not disclose facts or suppress relevant material, or is otherwise guilty of misleading the court may dismiss the action without adjudicating the matter. It was held that it is thus clear that though the appealant company has approaching the High Court under Article 226 of the Constitution, it has not candidly stated all the facts to the court. The High Court is exercising discretionary and extraordinary jurisdiction in Article 226 of the Constitution over and above a court of law is also a court of equity. It is therefore the utmost necessary that when a party approaches the High Court, it must place all the facts before the court without any reservation. If there is suppression of material facts on the part of the applicant or twisted facts have been placed before the court, the High Court may refuse to entertain the petition and dismiss it without entering into merits of the matter. So the court says, my lord, that the material facts which would affect, my lord, the litigation. Now there is no separation with regard to the facts. It's only that the intervention is made before the Supreme Court, and that does not now can we see next decision which I was citing, that is 2003 volume 11 9 FCC 401. Paragraph 24.
Yes.
Or should can be held with paragraph 24.
Yes.
In order to sustain, paragraph on page 420.
Yes.
In order to sustain and maintain the sanctity and solemnity of the proceedings in the law courts, it is necessary that the parties should not make false or willingly inaccurate statements or misrepresentation, or should not conceal material facts with a design to gain some advantage or benefit at the hands of the court, when a court is considered as a place where the truth and justice are solemnly pursued. If any party attempts to pollute such a place by adopting recourse to make misrepresentation and is concealing material fact does so at its risk and cost. Third party must be ready to take the consequences that follow on account of its making, at times lenient or liberal or generous treatment by courts in dealing with such matters is either mistaken or lightly taken instead of learning a proper lesson. And there is a compelling need to take a serious view in such matters to ensure effective purity and grace in administration of justice. Now, what I want to point out from here, Malad, that the court says that one should not make a false or knowingly inaccurate statement or misrepresentation, or should not conceal material fact with a design to gain some advantage or benefit at the hands of the court. Here I am not claiming any relief for myself. Here, Malad, my capacity as an intervener, I am here to assist the court. So, Malad, there is no, and I am not. It's not an allegation against me that anything on fact has been suppressed by me. It's only that I went for intervention and I am for intervention day. So that has to be seen in the light of that one. Now, Malad, may have a look on 2006 volume 3, page 100. And that is Malad paragraph 18. Paragraph 18, 18. It says that
Yes.
as per the law of pleadings, under under Order 6, Rule 2 of the code, every pleading should contain only a statement in concise form of the material facts on which the party relies or his claim or defense, as the case may be. Thus, the fact on which the plaintiff relies to prove this case have to be pleaded by him. Similarly, it is for the defendant to plead material facts on which his defense stands. The expression material facts has not been defined anywhere, but from the body of Order 6, Rule 2, the material facts would be upon which a party relies for his claim or defense. The material facts are facts upon which the plaintiff's cause of action or the defendant's defense depend on the facts which must be proved in order to establish the plaintiff's right to relief claim in the claim or the defendant's defense in the statement. I may pause here for a minute. There is an allegation that the fact regarding intervention is not brought to the notice of the. It is not a material fact. It does not affect the outcome of the case in any manner, or their pleading, their case does not get affected by intervention, would not make any difference here or there. And firstly, my lord, secondly, my lord, please see, as I submitted already, my lord, that the order passed by the order, my lord, it would have been a case if it was for the parties in personam. The law declared by the Supreme Court is a law, my lord, binding on all. Therefore, even if I am a party and I am not a party before Supreme Court, that would not make any difference as far as my position is concerned. And I still am around, we are arguing before the Lordship this case after the decision passed by the Honorable Apex Court. So, my Lord, can we see the Supreme Court has already passed the order? Yet we are arguing this matter before your Lordship on the issue as to what would be the effect of the order passed by the Honorable Apex Court.
These interveners in all the three applications are which category of persons?
Manu, they are nobody, Manu, they
No, qualification.
they are in the beard.
In all three IAs.
In all the three IAs, they are there. And Manu, my humble submission, in fact, this matter has been Manu, blown out of proportion. My humble submission is, Manu, may kindly see. We went before the Supreme Court and litigation is brought. We went for Manu intervention. Matter is 5 years, we came for intervention.
We've understood your point. Let us hear the
My
other.
submission is this, Manu, that it is not a material fact which was required to be disclosed. And Manu, we said,
Yeah.
at the outset I have submitted, Manu, there is a mistake. We should have mentioned it. We should have mentioned it. But the question is that when Malos are considering this aspect as to whether we should be given an audience or not on the allegation that we have suppressed this information, then therefore I have brought this law before the Lordship. Otherwise, Malos, because it's a admitted fact that we could have, that was a inadvertent Malos, only Malos, I on the very first day, I very candidly submitted it's some mistake on the part of me, Malos, as a counsel. But that intervention means that I can intervene there, I can intervene there. So, Maharaj, there is nothing, and Maharaj, it's not, there is no intention to hide. The Supreme Maharaj, the whole purpose, Maharaj, of deterring litigant from Maharaj, from assisting to Maharaj, conceal the facts is that it should have a deterrent effect because we should not be able to pollute the process. It's not the intention. Therefore, my humble submission is, Maharaj, that we have been permitted to intervene. Let Maharaj, we may be proud to address your lordship on the issue.
Mr. Rupra, you are following his arguments, adopting his arguments.
No, I'm not concerned with arguments because my clients are not having that. There's no such impediment. My client's case is very simple. Here are those people.
You had disclosed.
No, not disclosed.
You had not gone.
Then go to the Supreme.
You did not go.
No, Supreme Court, the MP rules were not in the It's not. The Supreme Court judgment itself says not that the line upon this Punjabumar. I'm concerned with most important thing is Supreme Court was not considering the MP rules also. It was only not the notification is applicable to the whole of India that was under consideration.
Then your IA has been allowed.
My idea has my lord has been seen.
Then you need not argue then. Then you don't have this suppression or non-suppression obstacle.
That doesn't concern. That will.
In this, and there are 10-12 persons who had not made 10 to 12 persons are such in this.
Out of
These 784 persons. In the second case, between Kumar's case, they were not able to
common factor is only about 7-8.
This 784, 10, 12 were not there. That's all. Only 10 to 12 persons were not there.
But not there.
In those numbers. And
No,
those IAs
Majority were there.
were there. And have given the IA numbers there. Along with the
Why have you mixed up both the categories?
because we have unfortunately see it did not disturb to us Maharaj, that this may be a problem. Otherwise, we would have written a line that we intervened before the Supreme Court also. But that it did not
But
disturb.
if ultimately the axe falls, it will fall on all.
That's what I'm saying. That's
The
That's what I submit. That Supreme Court that judgment is binding. Whatever the result may
see
be.
now what about merits?
Yes. Now Maharaj merits Maharaj.
The merits has been decided by the Supreme Court.
Not merits. Maharaj will please have a look on Devesh Sharma ji. And see, it's not so simple as they are trying to do it.
So it says, Devesh Sharma says, what have you assailed in this case? Let us see.
In this case, we have only said that we are the authority.
No, which case are we?
There in KP Nandan,
Which case should we take up?
Manoj sir, actually this one PhD level one players see both the PhD to say. Manoj sir seeing this PhD level. And one important document.
PhD level, yes.
Invitation of PhD appointed the petition to the place of this note mark immediately they are not in account.
So why should we go into all that?
That is what I mean. We just
So now the challenge is to annexure P1 and P2.
Now their case is
What is P1 and P2? Let us see.
one is the notification issued by the NCT. Another is the rules claimed by the state of Madhya Pradesh in line of the NCT code. Third is the advertisement for the PET examination. The NCT to get candidates.
But if I can submit before also. Now, the Supreme Court has declared that NCT, or the Supreme Court has declared that NCT.
वाले को बुलाओ, कस्टमाइज करो, पता नहीं ये इसको डिप करके एकदम से ऊपर जाना चाहिए, नीचे के नीचे जाना चाहिए। P2, let us see what is P2. P2 and P3.
P1, I will with P1 and P2 is the notification of the NCT. Okay, it is not ready.
Which has been quashed.
Which has been quashed.
Right.
How?
Graduation with at least 50% marks in B.Ed.
Yes, yes.
So that was against the NCT regulations.
The issue before your lordship is no. If I can submit. Supreme Court has declared that NCT regulation has not placed.
So Vilya, you are just an intervener. You are not a party right now.
So
let them argue.
जैसे मैं सिर्फ ये बताना चाह रहा था, ये आपको करेंगे, मैं बिल्कुल इंटरव्यू नहीं करता हूँ। मेरा सबमिशन सिर्फ इतना है कि अभी जो आपके सामने इश्यू है वो ये है कि 28(6) का नोटिफिकेशन एनसीटी का सुप्रीम कोर्ट ने इलीगल डिक्लेयर। Since the notification which permitted the B.Ed candidates to participate in the competition for primary teachers appointment, that has been declared. So subsequent rules which have been brought into force permitting these persons to participate in the process of or in the recruitment rules, B.Ed is put as a qualification for primary teacher.
Where are those rules?
For those rules are 2018 rules.
P1. And you will page 38. This is one from petition number 13768. Case number 7. Now, the lordship allow me, madam, I will put my case. Special what now case is?
सर वो रूल भी जो है
आप या तो आप
नहीं
मैंने additional let me explain my case first.
Where is the challenge to the rules?
Yes, that is in the prayer itself. The lordship will come to the prayer part. Prayer number 7.5 at page 30.
Okay, now where are these rules to be annexed?
This is annexure minus P1
One.
and the relevant part of it comes at page 38.
Schedule
Schedule
3.
3
Schedule 3.
starts from page 36. We are concerned with item number 3, Prathmik Shiksha, and the include part colors in column number 5. The all part. First qualification is कम से कम 50% अंकों के साथ हायर सेकेंडरी अथवा इसके समकक्ष प्राथमिक शिक्षा में 2 वर्ष का डिप्लोमा या उसके समकक्ष. So petitioners minors are those who are falling in part number 1. What diploma holders? Now their grievance is against this all part, which comes because of the notification of the NCT. अथवा 50% अंकों के साथ स्नातक तथा शिक्षा स्नातक बीएड इसने राष्ट्रीय अध्यापक शिक्षा परिषद द्वारा मान्यता प्राप्त संस्था से शिक्षा स्नातक की उपाधि प्राप्त की है, उस पर कक्षा 1 से 5 तक पढ़ाने के लिए अध्यापक के रूप में नियुक्ति हेतु विचार किया जाएगा। किंतु इस प्रकार अध्यापक के रूप में नियुक्त व्यक्ति को प्राथमिक शिक्षक के रूप में
नियुक्त होने के 2 वर्ष के भीतर राष्ट्रीय अध्यापक शिक्षा परिषद द्वारा मान्यता प्राप्त प्राथमिक शिक्षा में 6 महीने का एक सेतु पाठ्यक्रम ब्रिज कोर्स आवश्यक रूप से पूरा करना होगा. So as this is the outcome of the NCT notification, which is T228/2018 at page 7. I expect before this honorable court why this state of Madhya Pradesh came up with this. What has happened is, Manoj, that after this notification of NCT was issued in 28 June 2018, in several states it was not followed. One of the matter went before the Honorable Supreme in Ramshar and Maurya. Honorable Supreme Court observed that because this notification is not under challenge anywhere, the states are bound to follow it. So, when the state of Madhya Pradesh has rightly came up with the amendment in their rules in 2018, just after this notification.
And then where is the advertisement?
That advertisement, the Lordship will find, is along the P1 itself at page 43.
Yeah.
Yes, yes, we are finally hearing it. We'll finish in 10 minutes. What else is left now after Supreme Court's verdict? Hmm.
And this was already.
Hmm.
B.Ed and B. They are being sent out to the giving one year leave or 2 year leave. Go and do it.
Point it out from the RDA.
Go and do what?
Next document. And what is they have to.
Yeah, RTA और RTA और सुप्रीम कोर्ट का जजमेंट हम दोनों में तो पॉइंट आउट ऐसा नहीं सब जैसा ही कह रहे हैं कि सुप्रीम कोर्ट ने हमारा डिफरेंट व्हाट माय फ्रेंड इज रीडिंग दैट इज नॉट रिक्वायर्ड टू बी as far as
No, we'll hear you for 10 minutes. We'll hear you for 10 minutes on the question that what befalls on you now.
yes so that
What befalls on you now.
yes
What will be the consequence of this judgment of, I mean, they have set aside the NCT notification,
Yes.
the rules automatically go. Now what happens to the appointments made? So we'll hear you for 10 minutes only. 10 minutes.
Very short.
Yes, only 10 minutes, let them complete. Bas. Which appointments can be saved and which cannot be? Then- Yes.
Now, if your Lordship would come, Manoj, to the dates which are very specific.
Hmm.
The notification of the NCT, Manoj, came to be issued on 28 June 2018. The state of Madhya Pradesh, Manoj, came with their rules on 30th July. They were published on 30th July. The rules are actually on 28th July 2018. These are page 34.
So that means after this
P2.
after this advertisement, appointments must have been made because this is of 2020.
What I'm saying is the rules granting eligibility to the B.Ed candidates in state of Madhya Pradesh, they came up on 28th July 2018 after the NCT notification of 28th June 2018. Subsequent thereto came the advertisement. Now, when the advertisement came up, one of the repetitions were filed in the selection process. Before the appointments could be issued, the Lordship passed an order that because the notification had been quashed by the Rajasthan High Court, the matter is pending sub judice before the Honorable Supreme. All appointments which will be made shall be outcome of this court verdict. Now, this is very, very important. Manoj, so can we see the interim order 7th of July?
In which case?
In this 13768,
Order later.
7th of July 2020. And this was a specific issue taken up. Your Lordship may have a look on the interim order. And then I showed the idea which is very, very material, placed before the Honorable Supreme Court and this fact being hidden.
Yeah.
Please come to manage this order. Challenge here is to the virus of the eligibility funds. I'm reading from the first paragraph.
No, the read the second page of this.
The second page of
View of above.
yes, in view of above, as per an interim measure, it is directed that the recruitment in question and any appointment made shall remain subject to the final outcome of this petition. Now, prior thereto, my lords, this is the important paragraph. Learned Counsel for Petitioners in support of the challenge has relied upon the decision dated 25th November 2021 of Coordinate Bench of Rajasthan High Court in the case of Rajendra Singh Choudhary and another versus NCT and other connected matter, by which in similar circumstances the said essential qualification of B.Ed and the instruction of NCT were declared ultra-virus. It is further submitted against the order of the Division Bench of Rajasthan High Court. One of the candidates has approached the apex court in the petition number this and this. And the said petition has been entertained and as an interim review. The examination process of Rajasthan teachers eligibility test has been made subject to the final order of the apex court. In view of above as an interim measure, it is directed that the recruitment in question and any appointment made shall remain subject to the final outcome of this petition. That notices be issued to the respondent in this subject. So, my lords, can you consider that once the notification of the NCT was quashed by the Rajasthan High Court on 25th November 2021, it had the pen in the application reference to pursue the close respect of Honorable Supreme. The B.Ed degree holders from that day itself were ineligible. Once it is quashed, set aside, it's declared ultra-virus, it becomes non-est. The entire notification became non-est and still-born activity. So it had its effect from 28th June 2018 itself. Now, any steps taken by any of the state in view of the notification of 28th June 2018 becomes invalidated, illegal, and that is why, my lords, kindly see when the matter went before the Honorable Supreme Court, what has happened in Devesh Sharma. Very interestingly, my lords, it has been argued that we were just moved an application, it was not dealt with, no orders were passed, we were not heard, we were under the impression that we have just moved an application. Please see, my lord, how the things have traveled before the Honorable Supreme Court. Please have to look on the compilation. At page 100. Check compilation. It's not only the Rajasthan which was there on before the Honorable Supreme Court. Even they were there, I'll show from their IA. The order sheets before the Honorable Supreme Court, my lords, I am just providing the order. Page 100, if you also got it, ma'am,
Yes.
please see the first paragraph. A division bench judgment of Rajasthan High Court to be 25th November 2021. Apart from the appeals, these are very important. There are 3 repetitions as well before this court on the same issue. All the same, while dealing with these cases or facts, we would be referring to civil appeal number this and this, Devesh Sharma versus Union of India, which arises out of the order dated 25th November 2021, passed by the High Court in DB Civil Petition number 2 from 2020. Interesting was just post Devesh Sharma is one of the applicants before this honorable court by the respondent side. Para number 5. Out of 3 repetitions before us, 2 repetition number 137 of 2020 and 881 of 2020 are challenging the notification dated 28th June 2018 and the subsequent notifications. Now, this is very, very important, my lords. And the subsequent notifications issued by the government of Bihar and UP, respectively calling for application from eligible candidates, including B.Ed. Writ petition number 355 of 2022 again challenges the notification dated 28th June 2018. SLP 22923 of 2022 is against an interim order of the Calcutta High Court which denied relief to the petitioners who were seeking a stay of the notification dated 28th June 2018. So, Maharashtra, not only Rajasthan, several other states were also there. Please come to paragraph 10. During the course of hearing, this court has passed an order dated 24th August 2022 granting liberty to the Board of Secondary Education for different states, and other stakeholders to be impeached as interveners. Pursuant to this order, several interlocutory applications were filed which are being heard along with these appeals. Now, my lords, we have a look on the order sheet from the Honorable Supreme Court after 25th August 2022. 24th of August 2022, I provided the order sheet set. Their IA were well before the Honorable Supreme Court. Please have a look, my lords. The IAs were filed through their counsel, Mr. Amit Pawan. The first IA was filed, my lords, on 11th of October 2020.
That they don't dispute.
So, my lords, on 2022, the Honorable Supreme Court said, any step taken during the pendency of these proceedings having impact on the controversy out of which these proceedings arise shall be subject to final outcome or any further order that may be passed in these matters.
Where are you reading?
This is my lords, the order sheet that provided to. This is the first order sheet on 12th of October 2022 after filing of their IA. This is at page 5, not the first flag, page 5. Any step, but got it, madam, because the Honorable Supreme Court was dealing with all states.
Yes.
Any step taken during the pendency of these proceedings having impact on the controversy, out of which these proceedings arise, shall be subject to final outcome or any further order that may be passed in these matters. And thereafter, my lords, the matter was continuously heard. All these order sheets are there. Their IAs were listed. They even did not press their IAs to be allowed. Only thing was that it was an intention drawn that these persons will be given hearing at the time of final arguments also, and they were given hearing. Now, if the Lordship would have a look on their IA before the Honorable Supreme Court, on last occasion I provided and said, the IA was filed after the interim orders were passed by this Honorable Court in the present petition. And there was a specific mention in the IA that because our appointments have been made subject to outcome of the writ petition, this present writ petition, which is dealing with the notification of 28 June 2018, we would be directly affected by the outcome of the Devesh Sharma's trial. So this IA, my lords, may kindly have a look. 152181 of 2022, if your lordships are ready, because last occasion I provided the copy. Kindly see the paragraph. Page 21 of the IA. ID number 152181.
Yes.
Lordship, please come to paragraph. This is one of the IA, page 19.
Yes.
That the applicants are persons who have obtained B.Ed degrees and are otherwise qualified to be appointed as teachers in primary schools in the state of Madhya Pradesh. The qualifications for such appointment are governed by NCT's regulations of the qualifications, and since the validity of the correctness of the NCT notification dated 28 June 2018, fixing the minimum qualifications is under consideration, the interests of the applicants are directly and substantially linked in the matter in issuing the present special petition. It may be pertinent to narrate the facts peculiar to the state of Madhya Pradesh in the matter of appointment of teachers to elementary schools. Now, there they narrate all those facts. Please come to the material fact matters at page 21, paragraph E.
Yes.
Meanwhile, some of the candidates who have DLED qualification by virtue of which they were eligible for appointment as teachers in primary schools, even prior to the notification dated 28 June 2018, filed a writ petition before the Honorable Jabalpur High Court seeking quashing of the notification dated 28 June 2018, Madhya Pradesh Recruitment Rule 2018, and the advertisement dated 6/1/2022. The aforesaid writ petition was heard by the Honorable High Court when it was informed about the improved treatment of the Honorable Rajasthan High Court and also the pendency of the present special leave petition before this Honorable Court. Upon hearing the parties, the Honorable High Court was pleased to issue notice in the matter and by way of an interim measure, directed that the recruitment in question and any appointment made shall remain subject to the final outcome of the writ petition. True copy of this order is this. Now, this is that order of 7 July, my lords, by which the appointments were made. Now, Baraji, it is respectfully submitted that as a consequence of the aforesaid order, the selection and possible appointment of the applicant as teachers in primary school in the state of Madhya Pradesh has become subject to the outcome of the writ petition, even though 2018 rules which are in force in the state of Madhya Pradesh clearly permit the appointments of B.Ed candidates and teachers in primary schools. Paragraph 12. That it is most respectfully submitted that although the aforesaid writ petition is pending consideration before the Honorable High Court, its final outcome is directly dependent upon the final decision to be taken by this Honorable Court
No,
in the
what
present situation.
What is this H?
H is said writ petition is therefore pending adjudication before the Honorable Chandigarh High Court. This is perhaps, I think so, a typographical error on their part. They were dealing with the writ petition number 13768 of 2023. So therefore, my lords, I didn't write it. They are actually dealing with Chhattisgarh High Court, so it's a typographical error. So now your lordship may kindly see the entire contention in the IA was in respect to the merits. They sought impeachment because their appointments were made subject to the outcome of the present writ petition. Having noted the fact that the Honorable Supreme Court is seized with the validity of the notification, now my lords may kindly see what the Honorable Supreme Court said. The Honorable Supreme Court, my lords, was well aware that it's a 2018 notification with a challenge. Recruitments have taken place in several states. The notification has been quashed by the state of Rajasthan. The other states have also moved an application for impeachment. B.Ed candidates were also there before the Honorable Supreme Court, defending their selection and appointments. Now, my lords, the Honorable Supreme Court, I will not take much time. My lords, please come to para 62 at page 114. Taking note of what has happened, how the notification was issued, how it is violative of Article 21A, right to quality education, how it is violative of Article 1416, kindly come to para
62 of what?
of the compilation, 114, the compilation of judgments. The para 62 is of the Devi Sharma's judgment. Article 14. Now, Manu, they seek their continuation of appointment in the teeth of the Supreme Court judgment. Please see, Manu, what has been held in trust.
Yes.
We have already examined this aspect in great detail. B.Ed is not a qualification for teaching at primary level of classes, much less a better or higher qualification in context of primary classes. This finding is self-evident in the very admission of NCT, which mandates that all B.Ed qualified teachers who are appointed to teach primary level classes must mandatorily undergo a pedagogical course for elementary classes within 2 years of their appointment. Then, my lords, we kindly see para 64. Under these circumstances, we are unable to comprehend as to what was the pressing need to include B.Ed candidates who are admittedly not fully trained to take up primary classes. Consequently, the decision of the
No,
NCT.
fine, we understood, Mr. Kapoor.
So my lords, we kindly see the Honorable Supreme Court not only twice and set aside it being violative of Article 21A, also uphold the judgment of the Honorable Rajasthan High Court, being because that judgment was dealing with the legislative incompetence of the central government to direct NCT to come up with this qualification.
Yes.
So the consequence thereof, my lords, we kindly see page 120. Page 8, para 8. Consequently, the appeals are dismissed and the judgment dated 25/11/2021 of the Rajasthan High Court is upheld. The notification dated 28th June 2018 is hereby questioned set aside. The writ petitions and all pending applications stand disposed of in the light of the above order. Now, this is very, very important, my lords. There are IAs which were pending. They got disposed of in light of the order of 28 June 2018. And this was a very material fact, my lords, which they didn't disclose before this Honorable Court by submitting their IA, that they have already moved before the Honorable Supreme Court. And they were given their audience by examining the validity of the notification dated 28 June 2018. One of the applicants is Devi Sharma himself, in whose matter the judgment has been delivered. Now, my lords, their entire argument is that Eight appointments which is subject to the outcome of the rent petition should be safeguarded. So why don't we kindly come to the next Bhagwan Krishna judgment which came from state of Bihar. The compilation page 125. Sorry, compilation page 120. The Honorable Supreme Court, my lords, was well aware of the fact that the rules of Bihar, though are under challenge, the government of Bihar, the state of Bihar is not party. However, because the notification of 28 June 2018 was quashed and set aside, therefore, my lords, at page 124, it was specifically said the present petition stands allowed in terms of layer 8 to the extent the same relates to the notification issued by NCT on 28 June 2018. Consequential advertisements and other subsequent steps taken in pursuance thereof shall also stand invalidated. So, my advertisement would be for recruitment, these steps would be appointment, all these stands invalidated. However, my lords, then the court observed, the state of Bihar is not a party before this court in this petition, except we make no comment as regards to notifications issued by the state of Bihar, the legality of which have been challenged in this petition. But this court expects that the state of Bihar shall take into account the judgment of this court delivered on 11/8. So, Maharaj, may kindly see, only for the reason that the state of Bihar was not party, the Honorable Supreme Court restrained itself from making any comments on the validity of the notification of the state of Bihar. Though, Maharaj, from the words, it's very much clear that the state of Bihar was expected to withdraw such type of notification, which was outcome of the notification of the NCT dated 28 June 2018. Here, my lords, the lordship has seen the validity of the rules of state of Madhya Pradesh. So, the plea in this case, my lords, is not available with the state respondents and with the BI degree holders. Now, your lordship may kindly see, if a notification is declared unconstitutional or if a notification is declared unlawful, whether it will be effective from the date of the judgment or it will become non-est void ab initio as upon activity, invalidating all these steps taken in subsequent to that notification. So, my lords, as far as the prospectivity of a judgment is concerned, my lords, until unless it is held in the judgment, it is prospective in nature. The question of the notification relates to the date when the notification was issued. And that, my lords, this law is no more res integra in view of the recent Supreme Court judgment in CBI versus RR Kishore, which I placed, my lords, with time number 5 with the compilation. Your lordship would have a look on this judgment. This will answer the issue raised by the respondents that what about our appointments. So, understand the notification stands quashed. All steps taken under the notifications also are washed out. This is Maharaj from kindly see CBI versus RR. This is at page 126 of the compilation itself. The issue was that when the notification of CBI,
Which is that decision?
that is Maharaj, page 126, CBI versus RR Kishore.
Citation.
Citation is Maharaj civil criminal appeal number 377.
No, citation.
Actually, it is not still reported in. That is why is the text judgment of the from the Supreme Court website. In flag 5.
Yes.
This is the now these days the Supreme Court provides its own citation, so it is there, my lords, at page 126, 2023, INSC 817.
Also, para.
Issue was taken up in para 3 at page 131. Because the Honorable Supreme Court, when questioned notification, my lords, it did not decide whether it is retrospective or prospective. So, my lords, the question was raised at para 3 at page 131. What the constitution-based did not decide was whether the declaration of section 6A1 of the DPC Act to be violative of Article 14 of the Constitution would have retrospective effect or it would apply prospective. Now, Maharaj, this was answered by the Honorable. Please come to para 13.1 at page 165. And what arguments which My learned senior brothers can take up one which was dealt with, was taken up by Mr. Dada there
One.
at page 165.
Yes.
After referring to the question referred to the Constitution Bench, Sri Data, learned senior advocate, submitted that following three contrary questions also arise for consideration, namely, whether declaration of a law being violative of Article 14 or any other article contained in Part 3 is void ab initio under Article 13. What is the effect of such a judgment on actions taken or omitted to be taken during the period when the law remained operational? And whether there is a difference between a law held as unconstitutional for a lack of legislative competence and a law held to be unconstitutional for violation of Part 3 or other constitutional limitations. Now, my lords, this notification of 28 June 2018 was falling under clause 3 also. The Honorable Rajasthan High Court quashed it for the lack of competence of the central government as well as Article 21A, which falls under Part 3. Honorable Supreme Court upheld the judgment and again quashed it in the writ petitions from the state of UP and Bihar, being violation of Part 3. So, my lord, here the notification is unlawful as well as unlawful. Now, my lords, please come to paragraph 42, Roman Part 7. This your lordship will find at page 227. In the case of state of Manipur Supra, recently a three-judge bench of this court was dealing with an appeal against the judgment of the Manipur High Court, which had declared the Manipur Parliamentary Secretary 2012 as also repealing Act 2018 as unconstitutional. Justice L. Nageshwar Rao, speaking to the bench, observed that where a statute is adjudged to be unconstitutional, it is as if it had never been, and any law held to be unconstitutional for whatever reason, whether due to lack of legislative competence or in violation of fundamental rights, would be void ab initio. 22 and 23 of the said judgments are introduced here as under. Now, where a statute, I am reading this because this is very much important. Where a statute is adjudged to be unconstitutional, it is as if it had never been. Rights cannot be built up under. Now, this is very, very important. Contracts which depend upon it for their consideration are void. It constitutes a protection to no one who has acted under it, and no one can be punished for having refused obedience to it before the decision was made. Field J. Norton versus Shelby County observed that an unconstitutional act is not law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation as inoperative, as though it had never been passed. Constitutional law, be it either due to lack of legislative competence or in violation of fundamental rights guaranteed under Part 3 of the Constitution of India, is void ab initio. In Varam Kushit Peshika versus State of Bombay, it was held by a constitution bench of this court that the law-making power of the state is restricted by a written fundamental law, and any law enacted in offense to the fundamental law is in excess of the legislative authority and is thus a nullity. If declaration of unconstitutionality brought about by lack of legislative power, as well as a declaration of unconstitutionality brought about by reason of abridgment of fundamental rights, goes to the root of the power itself, making the law void in its inception. This court in Beatle versus State of UP summarized the following propositions. Whether the Constitution affirmatively confers power on the legislature to make laws subject-wise or negatively prohibits it from infringing any fundamental right, they represent only two aspects of want of legislative power. The Constitution in express terms makes the power of a legislature to make laws in regard to the entries in the list of 7 schedules subject to other provisions of the Constitution, and thereby circumscribes or reduces the said power by the limitations laid down in Part 2 of the Constitution. It follows from the premises that a law made in derogation or in excess of that power would be void, would be ab initio void. Further, after discussing the law laid down by the previous pronouncements, the principles were deduced in para number 28 to state that a statute declared unconstitutional by a court of law would be still born and known as for all purposes. And their knowledge, it was held that there has to come out with a judgment itself and its prospective nature. If it is not safeguarded, entire activities there undergoes.
Now the ball is in their court.
Yes,
Let them argue.
yes.
Yes. Yes. How do we save your appointment?
It will not be able to- Going into all this number, I just want to point out, he may kindly be seen taking, I'm satisfied with the number. My return, dated 3/9/23, may kindly be seen.
In which case?
That is not in the case of KC number 13768 of 20.
Your return.
My return. The case of KC.
Return or written submission?
In my return, that is 11572 of 23. Very, very.
So this is the return on behalf of intervener.
Yes.
Yes.
My lord, in this return, my lord, is page number 3. This is the chronology.
Yes.
28/6/2018. This is the NCTE notification which has been passed. My lord, 1/7/2018. This is the MP State School Education Service, Teaching Cadre Service, Traditional Service. They are implemented, in which year degree is also recognized as qualifying for becoming primary teacher. Subject to the condition that the appointee will be required to do a bridge course within 2 years. Now, this was not under scrutiny before the amendment. I want to make this clear. This statute was not under consideration before the Supreme Court in debate. Now, Lord, was 6/1/2020.
No, bridge course in what? What kind of course? It was there in one of the requisite qualifications in that or was there.
No,
And you have to.
The rules lot which will be challenged by my learned friend. The rules say,
No, but here, Mr. Rupra, the question is a little different.
we might.
One is that this judgment is not prospective. It has not been declared as prospective. Now, the result of washment of that notification is, or rather, not the result of that notification is that people who are eligible to be considered, which is a fundamental right under Article 16,
Yes.
they were ousted.
Yes.
People who had fundamental right of being considered for public employment were ousted. That means people with DLED or whatever. And people with B.Ed were appointed. So the deprivation is of a fundamental right. How do you meet that?
Not going into that, I want to point out what is the
Whether they would have been appointed or not, that's a different matter. But the right to be considered even was denied to them.
They were very much considered.
They were also considered.
They were DLED also
All
were
right.
considered.
But you were given preference.
More meritorious.
So you were given preference.
There is another thing, man. And Devesh Sharma does not deal with.
So where does the rule say that one of those qualifications has to be given preference?
No,
Is it there?
rules do not say so. Rules say that if you are B.Ed,
Rule says or. There are 4 or 5 alternatives.
you will be required to do a bridge.
No, who will be considered? Who will be given preference among those or? No.
Why not the preference is determined by an examination which B.Ed and DLED all have to pass. That is also one of the grounds, Lord, that I am not only B.Ed. After doing B.Ed, my Lord, have passed the competitive certificate also, which by itself is a qualification, which even DLED people had to. So, what is of my learned friend appears to be that Devesh Sharma in this case is identical. That's not it. First, I will distinguish Devesh Sharma from the peculiar facts of this case, and then I will argue that in spite of Devesh Sharma, if it squarely applies in this case, in spite of that, the existing appointees have to be protected. That will be my answer.
So that means this notification had not been issued by NCT, which was which was quashed, if that notification was not there, then would you have been eligible?
Because of the
How?
MP rules.
How?
Because of the MP rules.
No, MP rules was based on the notification.
They do not say. The MP.
No, MP rules have come two or 3 months after the notification.
Yeah.
So they are founded on the notification.
There is a difference. MP, firstly, they have dealt with this situation in an elaborate manner, page number 8. Your Lordship is pleased to be.
So a person who was entitled to be considered under the Right to Education Act, which is a statute, was denied by the rules, by amendment in the rules.
Those who were voting the qualification to be elect were not in it. They were also very much
So
concerned.
preference was given to B.Ed.
Absolutely not. No.
What is the stand of the state?
Not the examination pattern says that you have to pass the exam. So those who are found more eligible in that competitive exam, they will, my lord, be considered. That is the amendment. Not there is nothing like preference to those who have got B.Ed or those who have got DLED. No, that the passing of that certificate is absolutely essential for the purpose of appointment.
So were appointments made of people who were non-B.Ed and DLED only? Is somebody who did not have a B.Ed and only that diploma in elementary education only, they were also appointed?
They were also appointed. When B.Ed people were also appointed, everyone was appointed. We all faced the exam. So, Lord, please bear with me. And like
The eligibility to that exam was there with B.Ed as well as DLED.
yeah, Lord, that is sub-rule 5 of Rule 8, which says that ऐसे अभ्यर्थी जिन्होंने शिक्षक पात्रता परीक्षा उत्तीर्ण की है, शिक्षक चयन परीक्षा में सम्मिलित होना अनिवार्य. So you may be B.Ed, you may be DLED, it does not matter. You have to pass through that exam. So all of them, Lord, passed that exam. And those who were more meritorious, my Lord, they have, Lord, I have given the data in para 17. 25,000 posts were notified by the government, out of which approximately 22,000 appointments made. Out of these 22,000, approximately 14,000 candidates.
Where does the rule provide for that recruitment process?
Recruitment process, Lord, that is, they have mentioned in the system. That is, Lord, the rules start from page number 34. Page number 34. So there is one more aspect, Lord. They have not challenged one important circular which that is an extra IAS 7. IAS 7, Lord, reiterates the position. This is not the subject matter before this honorable. And IAS 7, I'll point out that also. Unless you challenge and get IAS 7 marks, you cannot get the relief if you are playing.
So where are the rules?
Not the rules are at page number 34 of the report. And my lord, we will come across the education qualification at page number 38. Prathmik Shiksha. Got the education qualification. Shaikshanik Arhata is given in the last one column.
No, the petition finishes at 32. P1.
P1 lord at page number
P1.
P4 it is.
हाँ कहाँ पर है रूल नंबर?
उसके इंटरनल पेज not maybe
रूल आपने पूरा पेश नहीं किया इसमें. रूल 1 and 2 पेश किया उसके बाद आपने अपेंडिक्स लगा दिया.
the petitioner has filed the rules as an exception.
P1 we have seen P1. P1 has rule 1, rule 2, and then straight away the schedule comes in.
Schedule. Now we come to the schedule lord. Point number 3. Prathmik. My lord, it says कम से कम 50% अंकों के my lord has got
Yes.
कम से कम 50% अंकों के साथ हाई सेकेंडरी अथवा इसके समकक्ष तथा प्रारंभिक शिक्षा में 2 वर्ष का डिप्लोमा या उसके समकक्ष अथवा 50% अंकों के साथ स्नातक शिक्षा संस्था बीएड, जिसने राष्ट्रीय अध्यापक शिक्षा परिषद द्वारा मान्यता प्राप्त संस्थान से शिक्षा स्नातक की उपाधि प्राप्त की है, उस पर कक्षा 1 से 5 तक पढ़ाने के लिए अध्यापक के रूप में नियुक्ति हेतु विचार किया जाएगा, किंतु इस प्रकार अध्यापक के रूप में नियुक्त व्यक्ति को प्राथमिक शिक्षक के रूप में नियुक्त होने के 2 वर्ष के भीतर राष्ट्रीय अध्यापक शिक्षा परिषद द्वारा मान्यता प्राप्त प्राथमिक शिक्षा में 6 महीने का एक सेतु पाठ्यक्रम ब्रिज कोर्स रखना आवश्यक होगा, अथवा कम से कम 45% अंकों के साथ हायर सेकेंडरी अथवा इसके समकक्ष तथा राष्ट्रीय अध्यापक शिक्षा परिषद मान्यता में this is the my main problem is
No, where is that provision for holding an examination? It's common.
that is not
So that this schedule pertains to Rule 8, which you have not filed. This annexure only pertains to Rule 1, Rule 2, and then straight away the schedule comes in. Rule follows. I don't know.
Same thing is here.
Since we all
Page number 56
of what?
of my return. My return with the intervener. Number 159223. Lord, it's the Rule 5 of Rule 8 में कंटिन्यू.
Page? Which page of the return?
ये पेज नंबर 55. पेज नंबर 55. जैसे ऐसे व्यक्ति जिन्होंने शिक्षण पात्रता परीक्षा उत्तीर्ण की है,
Just a minute, just a
you
minute.
know, come to this amendment bill, effective in first December 2020. The whole compilation should have been this is the procedure how it has been
You are
applied and
you are referring to 55 page.
पेज नंबर 55
Yeah.
राइटर नंबर 3 में लिखा है नियम 8 में नियम 4 के साथ निम्नलिखित उपनियम स्थापित किया जाए, अर्थात ऐसे अभ्यर्थी जिन्होंने शिक्षक पात्रता परीक्षा उत्तीर्ण की है, शिक्षक चयन परीक्षा में सम्मिलित होना अनिवार्य होगा। नियुक्ति की प्रक्रिया तथा समस्त वर्गों के अभ्यर्थियों की योग्यता सूची अनुसार तैयार किए जाने की प्रक्रिया शासन के कार्यपालिक आदेश द्वारा विनिर्दिष्ट की जाएगी। इसमें हिंदी व अंग्रेजी माध्यम से स्थापन करने वाले शिक्षकों हेतु पृथक पृथक चयन प्रक्रिया निर्धारित की जा सके। Now the amended portion makes it obligatory on the part of all candidates to first appear in teachers eligibility test and clear the same, that even if a candidate has passed his B.Ed, D.El.Ed or whatever, he is not eligible to be appointed as primary school teacher until unless you pass the eligibility test. The passing of this eligibility test, my lord, is itself a qualification which has been treated by the government of India as a substitute, my lord, of the requisite qualification. And thus, even if a B.Ed teacher wants to become a primary teacher, he has to pass the eligibility test. The passing of the eligibility test, my lord, is by itself.
The stage of recruitment is, the first is that you have to be eligible as per that schedule.
My lord.
Is that right?
Yes, my lord.
You have to have one of those
One
qualifications. Then which is the first selection process?
Then after that, you have to appear in the exam.
Which exam?
This the teacher's eligibility test. The passing of this eligibility test is itself a certificate, and once anyone has that certificate, he is eligible to be appointed as prime. This is very important law. Position of Madhya Pradesh is slightly different. I'm not saying that Devesh Sharma is irrelevant. No. It deserves the kind consideration of. Directly going into the law not without first examining the our case lot. Examining the now Lord, please see the primary page number 3 of my return is very page number. What is this primary school teachers eligibility test? This is very important, my lord. They have appeared in this exam, which has got 4 subjects. Pehla, child development and pedagogy. Number 1, 2, language 1, language 2, and mathematics. And environmental studies. You may have done BA, DLED, whatever you have to pass. And there are 30 miscellaneous questions which have to be asked in each of these subjects. So you are well versed in child psychology, everything. The once you pass an exam, that by itself Lord confers some qualification unto you that yes, you are. So this exam, I appeared in this exam, the pandemic set in. I am on 20 page of the road column, on 2511 items of 5, 2511 2021.
Mr. Rupta, we have seen the effect this appointment of BEds are having on those people who are otherwise.
We are occupying
So that means preference was given to you, or you in larger number because of a higher qualification could pass through this teacher's eligibility. Is it? Is that the situation?
No, that is not. You may be BA, you may be DLA, it does not matter. The merit list is prepared on the basis of your marks obtained, you obtained in the test.
Teacher's eligibility.
Exactly. So if you are BA and you get more marks, and lot of the subjects which are there in this language test,
But the fact-
most concerning lot any two teachers.
The fact remains that you are otherwise not eligible to even sit in the teacher's eligibility test. If the rule was not amended, or if the NCT notification was not there, you are not eligible to even sit in the eligibility test. So that question is settled now by Supreme
We
Court.
are not questioning next number, we cannot question. The notification issued by
So could you have appeared in the test? How?
and we can from a judgment of अगर the RT है
The rule में होगा ना? We have the rules now, the entire rules.
इसमें RT है
What is rule 8? नीति भर्ती. शिक्षण पात्रता परीक्षा में भाग लेने हेतु पात्र होने के लिए अभ्यर्थी को निम्नलिखित शर्तें पूरी करनी.
का ऑब्जेक्शन से किया है बीएड को आप नहीं क्वालिफाई करेंगे. इनका ऑब्जेक्शन ये है कि अगर बीएड वालों को अगर आप एलिजिबल नहीं मानते तो कंपटीशन कुड हैव गॉट रिड्यूस.
बस
इनका कहना ये है कि अगर बीएड नहीं होता तो अदरवाइज दे आर नॉट सेइंग the recruitment group permitted us to participate, so they say that competition would have got reduced and only DLED candidates would have been eligible. But they have forgotten RTE.
So does it affect their right to be considered? Does it adversely affect the right to be considered or not?
NCT notification has been issued by has been declared to be illegal by the Supreme. We have to question. The rules framed pursuant to that cannot be questioned. The question is that under RTE, Commissioner, please have a look on the Devesh Sharma judgment.
तो रूल 8 से बताइए कहाँ पर है? इस एलिजिबिलिटी टेस्ट में पात्रता एक आयु की है, उसके बाद शैक्षणिक हाल था,
My lord, if my lord wants to examine the entire process, he can just go through these rules. My lord will not be.
Yes.
Entire rules have not been passed.
No, I have the entire rules.
Entire. Then Lord, we can see rule 5. That is how Lord Africa America begins. In PMO, may the benefit to the elite.
Unfortunately, I have two for percentage right. Schedule 3, Maharashtra, I have to on schedule 3. Schedule 3, area number 3.
My lord's copy is amended up to 2020 to allow certain finding statement. Your lordship copy is after 2020. Because there is an amendment in Rule 8 which has taken place in 2008.
Rule 8.
My lord, let us check whether approved 4 of Rule 8 is mentioned therein or not. Sorry, Rule 5. Rule 5.
So Rule 5 is not there.
5 of Rule 8.
No, it is not there.
It is not. So therefore, my lord would need to refer to my number 8. This Rule 5 of Rule 8.
This प्राथमिक शिक्षक ने
This Rule 5 is very.
No, but this Bachelor of Education B.Ed is there in the schedule. Find it to this. In the schedule.
Yes, yes.
Rule 8, sub rule 5.
Rule 5.
Right. Sub rule 5 is not there.
Rule 5. Therefore, I humbly
This
request
is up to sub rule 3. 3 or 4 का.
4 होगा. 5.
ये amended नहीं है ना. ये unamended rule है.
Thank you. Rule 5 will depend on.
I think this case is consuming a very long time and the people, other cases are being delayed, so we'll take it up as part heard tomorrow.
What?
So you have to only satisfy that if they can satisfy that the right to be considered was abridged, was curtailed or was restricted, then they have a case. If it was not a fundamental right to be considered for public employment is a fundamental right. That cannot be curtailed. So then your appointments have to go. So we'll hear you tomorrow.
My humble submission that what the issue is that you have these rules of 2018 2018 so far they
No, if we simply go by that, then everything goes, the advertisement goes, the appointment go. Because the judgment is not prospective. So it will deem to be retrospective. But we are going a step ahead and going into the rules.
just for 1 minute. My submission is this that we concede to the as far as I am concerned, we concede to the situation that notification is declared illegal. Consequently, the rules of 2018 so far they permit a B.Ed candidate to appear in examination that is declared illegal. Because the natural follow-up of that principle regulation is that. The question would be that whether the candidates who have been appointed at candidate having their qualification already having been appointed, can their appointments be said to be illegal in view of the law laid down by the Supreme Court in Davis Sharma itself and under the and read with the RT Act 1. The RT Act makes a provision. Well, Supreme Court has declared that NCT regulation illegal because NCT regulation says that BEd is not a one of the qualification. But NCT or the RT Act says that the candidates who have done BEd qualification, they will be held eligible for appointment as a primary teacher if they are subject to the next course. That is under section 23 of the RT Act.
No, so the problem is not your appointment. Problem is that when you were undergoing the process, were you actually eligible to be to step into the recruitment process? And if you were allowed to step into the recruitment process, then did you curtail their right to be considered?
This English is actually Balram Bahira, minus 2017, which says that if vacancies are parted with the ineligible candidates, it's only to Article 14 and 16. And eligible candidates can raise this point.
Yes, why should you go anywhere else? Davis Sharma takes care of it.
Davis Sharma is silent on that aspect.
Davis Sharma says that.
So we'll hear him tomorrow. We'll hear.
Quite a
Tomorrow will be a regular bench.
I just sum up within 5 points. The FCA Balram Bahira directly deals with the points raised by the Lordship. That is ineligible because ineligibility is now determined by the Honorable Supreme Court. BEd candidates are ineligible.
Nice. I started hearing without realizing that it's an ad hoc bench.
And what the most important thing is that the learning field has not argued on sub-rule 5 of the 8 which was amended in the year 2022. My learned friend has not also disclosed the date of advertisement is 6/1/20 and this petition is filed after more than 2 years, my lord.
In
So
Rajasthan, it was filed
entire
after 4 years.
selection process is over.
In Rajasthan, it was filed after 4 years. Madam. The validity has been examined.
So, satisfying, my lord.
Then we can't mark it partner.
If the Lordship will take it up, I'll just make submission 5 minutes to wrap up with the reply.
You can't sacrifice. We can't sacrifice the other cases. People are waiting in the other advocates are waiting in the queue.
Earlier 10 minutes, as 5 minutes are like, we have to just have that citation, or because I'm so afraid, lest anything may follow.
If it can be taken up at the end of the list to take some at 3:30 or 4. Thank you.
This is an So we have 43 cases and there is a special bench also.
Mark partner, the bench can be formed.
What is the government doing? They are waiting for the verdict.
What they have done is that they have given appointments to all these BEd candidates.
What are the government doing after the Supreme Court verdict? They are waiting for the verdict.
Appointments have been given, we are in service.
And they are also in service.
They are also.
They are not in service, now maybe Mark. In a when they are saying that we have been given appointments, what should we mark? Look more, no appointments to be given.
No, it is obvious that a person with a higher qualification has a better chance of succeeding in the test. Obvious. A BEd man will have a better chance to succeed. So more number of BEds must have passed the test and therefore they were appointed.
And DLED and remaining BS. 1200.
Importantly, Mark, Honorable Supreme Court.
And they are asking for every teacher which covers really all the courses. Whether that circumstance was there in Devesh Sharma or not,
So this point has not been raised by anybody before the Apex Court.
no. Because MP rules were not under consideration. That's what I expect. Some
Which point? The Patagogo point was decided for the Honorable Supreme Court. BEd candidates are not even trained to teach primary classes. Their single day continuation is in violation of Article 21A.
Whether the appointment for appointment, you have to wait to that or not. It's a moot question.
But that was there with the state of Rajasthan also.
Another point against you is that you were not even eligible.
Yes.
Say Rajasthan.
Without that
in
DLED,
the state of
you
Rajasthan.
were not even
Because
eligible.
of state of 6 months bridge course, had been hard qualified, but there was occasion of 6 months bridge course.
State of Rajasthan, we had candidates got
All right, if you mark it part out, then what?
Bench can be constituted by the Honorable Chief Minister at any time 3:30 or 3. The bench can continue, can speak, or it's a matter of merits having impact on large number of persons for a bench.
So it is that arguments have been advanced by the Honorable Counsel for the petition. Next one. The arguments of the Honorable Counsel for the interveners have also been heard partly. Interveners stroke respondents have been heard partly. Next one. Since due to paucity of time, the fact that there's a special bench today, and there are a lot many cases in this bench have to be attended to. What and it's this case is marked as part heard. We heard the day after today. After seeking orders on the administrative side, so subject to orders on the administrative side of Honorable the Chief Justice.
Yes, sir. Tomorrow because I want to go back and come again from Rajasthan. Tomorrow it will not. So it may be very difficult to provide
Right, and tomorrow we'll see.
tomorrow.
Then special bench would be possible.
Huh?
Always possible.
Then we'll place it next week.
For next week would be nine. Adjusted for 2 weeks, what I gave well in advance. All the honorable.
Subject.
Because my case is slightly different from Mr.
It will
Gill.
be taken up in the week
Week
commencing
commencing 30th of
Rather than day after tomorrow, why not sign it?
16th October. Week commencing 16th October.
30th October.
So, no, not 16th October. 16th October.
My lord, 16th October, I don't know.
Not even next week.
Please take it. Heavens will not fall. Week commencing
Day after tomorrow, I'll be
there.
there.
Week commencing 30th, I'm there, man.
No, no,
2 weeks.
we'll forget everything that we've
Day after
we'll forget everything that we've heard.
Taken day after.
You've completed your arguments almost.
My lord, I have not completed.
Mr. Gildial and your arguments are almost the same.
What we did from the government, I will take some time. It was a good question, a very important.
Then-
Day after tomorrow. If I don't, day after tomorrow, I'll make my own arrangement.
Then we will not mark it fast.
But then the entire exercise will be
Let the case be, due to paucity of time, let the case be taken up in the week commencing 30th October.
problem would be that these persons won't continue services despite the fact that they are unpaid. And it's directly
Because we have
impact on the children.
completed more than 6 years, 6 months, 1 year.
It will have direct impact on those single parents who are not even 3% paid.
6 months and 6 months and 20 days will not.
Then can I get a date because I have to come up.
Tell us some days.
So, it would be taken up around on 27. Because 28 is also working here, perhaps.
Means, there, I'm there. 30th October, I'm there.
30th October.
30th is Monday, my lord, we have a shortage of. See? Want to ask you. Because 30th again, my lord, Monday. Tuesday is all this.
Second of November. Second of November.
Second November.